Right, good evening, listeners. We are once again here on the subject of law, you and the law. And we are once again privileged to have the Salgaonkar Law College backing us fully to explain to you all what are the different segments of law. Today we have with us Dr. K.S. Rao, who is an expert in about rights of arrested persons. Usually we wonder why a person is arrested, why, what happens, etc., what should be done, what should be not be done. So today, to explain to us all the legalities of arrest, Dr. Rao will explain to us step by step how and why and what happens in these situations. Doctor, let us go to the first step itself. We always hear in the newspapers that an FIR has been registered or not been registered. What is actually the real situation supposed to be?
Yes, sir. Whenever an offence is committed, then one of the person has to go to the police station and inform that there is a particular place, there is an offence occurred. Then the police officer is having a responsibility or a duty to record the FIR.
Okay.
He will record information that is actually in normal parlance we are calling first information report.
Right. FIR is first information report.
Yes.
Okay.
To record FIR, police officer has to finalize whether offence is a cognizable or non-cognizable.
Okay. So what would be a cognizable offence?
Yes, sir. An offence for which police officer can arrest without warrant, like we can say simple language, serious offences are cognizable and less serious offences are non-cognizable, which was mentioned in Criminal Procedure Code in the schedule.
For the purpose of our people, can you tell us what would constitute a serious offence? What is a serious offence?
Like murder,
Okay.
theft, rape,
Okay.
dowry death.
Okay.
Even we can say that what is happening in some of the places, demolishing or damaging the even idols and that also we can say is a cognizable offence.
All right. And what would be a non-cognizable offence?
There are the petty offences, a small fight between the people in a corner in the house or something. Not a severe offences.
Okay.
And less than, generally we can say, in general, it may not be exactly, offences punishable less than 3 years, mostly non-cognizable.
Right. So doctor, let us take a situation here. Somebody is drunk and he has hit or slapped his wife or done something very, very wrong.
Yeah.
Would that be a cognizable offence?
Yes, sir. What happened, 498A, it is a domestic cruelty to the wife. If it comes under, then it is a non-cognizable.
All right, okay. Now, doctor, see, the situation is this. We say that unless a person is proven guilty, he is still innocent.
Yes, sir.
So why should he be arrested?
Good question. The principle of an accused person shall be presumed to be innocent till he proved guilty.
That's right.
The main reason for that is burden of proof lies on the prosecution.
Right.
Prosecution has to prove it, he has committed the offence.
That's right.
That is the intention of the the rule what you said.
Yeah.
But why we are arresting is, as a precautionary measure, we have to arrest him. He cannot commit further offence or he cannot escape from the place, because at the time of trial, he has to attend the court. He has to be there.
That's right. Okay. So an arrest is mandatory.
Yes, sir.
In this cognizable offence situations.
Yes.
Now, what about a situation where a person is accused of something, there is no police officer on duty?
Yes.
Can the other policemen do something?
Even a private person, you are saying?
Yeah, that's right. Can they?
There are certain offences. For example, what I told you, cognizable and non-bailable offence.
That's right, yeah.
Like these type of things when they are doing damaging the idols.
Yeah.
Right? Definitely even a private person can go and arrest.
Oh.
Yes, even private persons can arrest, not necessarily police officer, when it is a cognizable and non-bailable offence. Like what I told you, that example. Another one in one of the place in Kerala, KP Salim versus State of Kerala. They are preparing in locality, residents, some of the people are preparing brown sugar in an injectable form.
Okay, all right.
So immediately the local people arrested them. Only the procedure, immediately, as early as possible, they have to submit that person to the nearest police station. They cannot keep them with them in their custody. Otherwise, these private persons will be liable for wrongful confinement.
So when you say a private person can arrest in a cognizable offence,
Yes.
he has to actually be taken to the police station.
Yes, as early as possible, they have to hand over to the police people.
All right.
Otherwise, these people will be liable for wrongful restraint.
All right. So I think it's quite clear here that in a situation where there is a serious offence and there is no police inspector, you can actually arrest that person and take him to the police station where the police will then take care of the situation.
Yes,
Wonderful,
sir.
my goodness. That I must confess, I did not know this, and I'm sure most of our people who are listening to this program do not know this intricacies of the law. So I'm very happy that you are clearing our doubts. Now, there is such a thing as a warrant of arrest.
Sir.
In what situation does a warrant of arrest come into play?
Yes, sir. As earlier what I said, that non-cognizable offence means an offence which are not so serious,
Yeah.
less than 3 years punishable,
That's right.
majority of the offences.
Yeah.
Unless magistrate issue a warrant, police officer does not have a right to arrest.
Okay. So a warrant is required for non-cognizable offences.
Yes, sir.
I see. Okay. Now, what would be the procedure in terms of the actual arrest? Now the police officer has arrested him. What is he supposed to do with this guy?
Yes. When the police officer approaches to arrest a person, he has to follow some rules. Number one, he must have the identity, the name, identity tag. What
The
is
police
his name?
inspector must have his name on
Exactly.
his shirt. Okay,
Yes,
all right.
exactly.
Okay.
Identity tag has to be there.
Right.
Then he has to inform him why he is arresting him.
Okay.
Grounds of arrest he has to tell. He cannot use excessive force on the person. Just inform. In case if he himself submits himself, then no need to, you have to use, you no need even touch also the person.
Okay.
Unless he resists, then only you have to use force, otherwise don't use the force.
Okay. So he has arrested him. There was no force.
Yes.
And what does he do with that person? He puts him in jail directly?
No, he has to first take to the police station,
Okay.
and within 24 hours he has to submit before the magistrate.
Okay. All right.
Magistrate has to satisfy that whether this arrest is genuine or not.
Okay. That is in the case of non-cognizable offense. What about a cognizable offense?
Yeah, even cognizable offense.
He has to put him in jail?
No, sir, it is a police station only.
Only
First,
police station?
yes, first they will arrest and they will take to police station because they want to do some interrogation or some investigation with him.
Okay.
Right? So first they will keep in the police station. That's why we are calling police custody.
Okay. So yes, so I have heard this word police custody. I have also heard the word judicial custody.
Sir.
In our friend Mr. Chidambaram's case, there was a lot of talk about that.
Yes.
So what is the difference between police custody and judicial custody?
Yes. Police custody means the accused person is under the control of a police and who are doing investigation about the
All right,
case.
okay.
Once it went into judicial custody, they are out of the police control.
Okay.
They are under the judicial magistrate order. They will send to the jail or judicial lockup, wherein police cannot go and interrogate with the fellow without magistrate's permission.
In the judicial custody?
Exactly.
Okay, right. So why the difference?
Yes, sir. Because police custody, according to general concept, there is a limit. You cannot do too much interrogation, and beyond the particular limit, you have a particular time we are giving. Maximum 15 days we will give time.
Okay.
Maximum 15 days we will give time to you in a police custody. More than that, sent to judicial custody. Enough your interrogation. If you want, we will keep him in a custody only, but not more than that.
Right, doctor. Let's change the subject a little bit. What happens in the case of a woman or a child?
Yes. For women, arrest is concerned. Preferably, woman police officer has to be there.
Okay.
Preferably.
Right.
Number one. Number two, there is a rule, after sunset and before sunrise, a woman cannot be arrested unless it is an exceptional cases. Even that exceptional case also, woman police officer has to be there. She has to take a prior approval from the magistrate. We want to arrest a woman during the night time. Otherwise, there is no chance to arrest her.
And why would that be the case? Why such restrictions for women?
It is a common point that because she cannot be tortured and because we know that a male and woman actually the atrocities cannot be done or whatever night time when we are taking her respect will be in the society will be affected.
Right. Okay. So that's it. And what about a child?
Child also. We are not using the word arrest for child because we are having a juvenile justice system.
Okay.
There is a Juvenile Justice Act. According to that, they will use the word apprehension, apprehended.
Okay.
We are not using the word arrest.
Okay, right.
Once apprehended, he will send to the safe place, not to the lockup.
Okay.
He will not be taken to the police station or lockup. There is immediately they have to hand over to safe place. There is a safest safety place is there according to juvenile justice system. That is some homes are there according to government.
Okay.
Right?
Okay.
In that they have to send to them.
Right. Okay. And sometimes we see on the streets people in handcuffs.
Yes, sir.
What is that situation? Why are
Exactly.
handcuffs?
Very clearly, several times it was mentioned even by the Supreme Court also. You cannot use excessive force, including handcuffs cannot be used and parade cannot be done. So there are certain people are doing that. They are using handcuff and they are parading on the streets. Even in Goa, around 2014, in one incident, one of the person was arrested and he was paraded on the street. Then High Court gave a suspended the concerned police constable or police officer and 25,000 rupees compensation they paid only because used the handcuff and paraded from house to the police station.
Oh, I see.
So very clear instructions. And if you want to use that, take magistrate permission and use it.
Okay. Now, let us take another kind of a situation. There are all kinds of thieves and people in Goa and in fact all over India. There is this guy who's definitely done something wrong and the police have caught him but suddenly he disappears. He's hiding somewhere. What does the police do in such a situation?
Yeah. If police officer suspected that person is hiding in a particular house, who is the occupier of the house, police officer has to give a reasonable notice. Please, he has to inform that you allow us, we want to come and search in your house.
Right.
Please, because the reason is there may be a particular woman out there, they may not come. There is a parda nashin earlier. So you allow them to move from there and allow if in case if the occupier is not permitting them, police officer is having a power to break down the door or window and he can enter.
He can break down the door and
Yes. When the occupier is not, because police officers are having a reasonable suspicion that fellow is hiding in that room.
Oh, I see. Okay. And then, assuming he finds him, what happens then?
Immediately they have to arrest him and they will produce before the magistrate within 24 hours.
Oh, they have to produce before the magistrate?
Yes.
There is no need of a written signature from the magistrate to say you can arrest him because he was hiding.
Because see, in every case they need not take permission. Whenever there is a cognizable offence, they have a right to arrest without warrant.
Okay.
So they are arrested and they will go.
All right. Now, if an arrested person is unable to appoint an advocate due to his poverty or whatever, there is a poor person and all that sort of thing, is there any procedure to apply for bail?
Yes. Legal aid system is there. According to, we are having Legal Service Authorities Act. In every courts, we are having legal service authorities. According to legal services, there is a panel of legal aid advocates are there. When accused appears before the court will ask him, where is your advocate, who is your advocate? If he expresses, because there are certain outsiders comes and they commit an offence in Goa and they will be arrested. And if they ask, where is your advocate, he does not have his relatives only here. Then court will ask that, where is your advocate? If he says that I don't have an advocate, then the concerned magistrate will appoint one of the concerned advocate who is there in the panel of legal aid advocates. So provide him as an advocate for him. Legal aid advocate at the state cost. The expenses of the advocate will be paid by the state government.
Just as a matter of information, the state is paying this particular advocate. What is the amount they pay?
Yes, earlier days it is a very nominal. At least nowadays little better. But one thing, sir, it is a legal aid. The word when it is a legal aid, so of course advocates are voluntarily has coming, and amount is not like what we are getting in ordinary practice in regular cases.
So what roughly what is it? Roughly.
It is not like per hearing case, sir. It is per case they will give for a 4,000 or something, sir. It is not like a per hearing case, except in High Court.
But why would somebody volunteer his name if the payment is so low?
Sir, see, when we are doing in life, one point always we have to remember. Everything is not for ourselves only, we have to think about you also. So, for society point of view, there are several advocates are coming. And there is another part, there is getting an experience also.
Okay. So what you're saying is basically junior people are on that panel because they just want to get some experience.
It is not necessarily budding junior advocates only. There are some senior advocates also coming and voluntarily accepting. But of course, what you said is correct. Around 5-6 years experience people, come on, let us have an experience. Come on, we will also having that. There is one thing they have a social responsibility they are feeling, and another way experience also coming.
This is a completely out of the way question, Doctor. Jethmalani, who recently expired,
Sir.
he is considered to be was considered to be one of the most expensive lawyers.
Sir.
Now, is there no limit to how much they can charge under the law?
Sir, what happened, it is only depends on the capacity of the person.
And the case.
Exactly.
And the case.
See, every person is not going to pay lakhs of rupees or crores of rupees to an advocate. What happened when you are getting a seniority and you are having a case, a matter is like that, then depends on that the people are paying that. It is not compulsion that it is an expensive or not.
Now, take the case of our friend Mr. Modi, Nirav Modi.
Sir.
He is lying there in jail in London. Now, he's got plenty of money.
Sir.
So, is it that money can actually save him? People with a lot of money, though they are actually in the wrong, with a very clever legal person, they can get away with it.
Okay. Very simple, sir. Unless a case is proved before the court of law beyond the reasonable doubt, we cannot convict a person, that is a law. Right? Very simple. Beyond reasonable doubt, it has to be proved that he has committed. As long as that evidence is not sufficient in the court of law, court cannot do anything. This word, what I am saying, that whether he is a corrupt or not, unless we have a perfect evidence, we cannot comment on that.
Let's go back to this situation where the person is in judicial custody.
Sir.
Now, is there a period?
Yes, sir.
How much?
Once a person is arrested, police custody maximum 15 days.
Okay.
And those offences which are punishable up to 10 years, 60 days he can be in judicial custody.
Okay.
Right, sir? And punishable above 10 years, 90 days he can be in judicial custody,
Okay.
as long as police officer not submitted investigation report.
Right. Okay.
We are calling charge sheet.
Okay.
If charge sheet not submitted, police officer unable to complete investigation, 90 days are over, he has to be compulsorily released on bail if he applies for bail.
All right.
That's why it is known as default bail, compulsive bail or default bail.
Okay.
The moment 90 days or 60 days as the case may be completed, if charge sheet not submitted by the investigation officer or the police officers, if he applies for bail, magistrate has to compulsorily release him on bail.
Okay. Now, when you say judicial custody, does it mean jail or does it mean?
Yes, sir. Judicial lockup or jail.
They can put jail.
Yes, sir. Means, but he is an under trial prisoner. He is not like a convict. In jail, there are two categories, sir. Under trial prisoners are there. Convicts will be there. Under trial prisoner is having his own some rights. Then he is not treated equal to the convict.
So he gets a few benefits.
Correct, sir. Even in the dress is concerned, he wears his own normal. He is not having like a white dress like a convict, and all those won't be there.
Right. Well, doctor, thank you so much for educating us on all this on this thing about arrested persons, and I'm sure now our people will be a little bit more careful of how to deal with such situation. Thank you so much for your time.
Welcome, sir.